feminism cannot afford to vacate the justice system or state institutions as key sites of feminist resistance, even as we recognize and challenge the state's increasingly coercive and punitive interventions that deny women and others access to rights and justice.
I mean, I think we all know who Pragna is and what Pragna's done over her long career in terms of women's rights, and particularly in relation to women victims of violence. And there's so many aspects of the law that we just wouldn't have had it not been for Pragna and also Southall Black Sisters. So it's just an absolute privilege and delight to introduce the keynote today, which is Pragna.
Thank you so much, Azia. I can't tell you. No need, wait, no need. I can't tell you what an absolute honor and privilege it is to be here, to be invited, and to talk to all of you experts. It's quite nerve-wracking, believe me, it really is. So, and to talk at the end of the day, somebody said your task is to keep everybody awake. So I really hope that if I can just prevent somebody from nodding off, I'll have done my job. Okay, so I've been asked to talk and reflect on some of the key issues and themes, and there have been many, and they've been absolutely rich. We could mine every single aspect of every single discussion that's taken place today, and I don't think I can do complete justice, but what I can do is try and look at some of the key issues and themes that have also resonated in my work over the years. So the title of my talk makes clear that at the heart of women's fight for survival from all forms of gender-based violence is really the struggle for freedom, rights, and accountability. Since without that, there can be no meaningful survival. So this struggle for freedom entails not only freedom from harm and torture and related issues of poverty, homelessness, immigration insecurities, and trauma, but also freedom to speak out, to move freely, to exercise bodily and intellectual autonomy. And a lot of the discussions today talked about some of this. In short, the freedom for women and girls to determine their own lives on their own terms. So the question then is, what are the impediments to female self-determination, and what strategies do we adopt to create the social conditions conducive to creating feminist cultures of resilience, survival, and resistance? My starting point is facilitating women's access to protection. If we're talking about survival, it's a necessary first step. But at the present, it's a difficult thing to do. Achieving this under the shadow of austerity, the post-COVID-19 pandemic, the cost of living crisis, and resurgent nationalisms, racisms, and religious fundamentalism has not made our task easy at all. Some of the themes emerging from the discussion today refer to the ways in which community norms, state inaction, and abuses of power disrupt women's attempts to survive violence. On a daily basis, women are prevented from asserting their rights and freedoms. Their complaints of domestic and sexual abuse are routinely disbelieved, ignored, and depoliticized by both state and community institutions for multiple reasons. Lack of awareness of what constitutes abuse, lack of knowledge of the law and legal processes, as well as community-based forms of arbitration that are steeped in rigid patriarchal norms, are just some of the immense barriers that women face. Others today have highlighted the ways in which minority and migrant women who report abuse, for example, are also subject to state forms of violence, infrastructural violence that was described earlier, and discrimination rooted in the politics of racism and exclusion. So most of these themes have certainly run through my own history of frontline work and political activism. And I want to draw on this work to address the question about strategies that we adopt for survival and resistance. Last January, I stepped down after completing 40 years as the founder and director of Southall Black Sisters, an NGO, as you know, that was set up to meet the needs of marginalized and Black minority women subject to all forms of gender-based violence. Throughout these years and since, my overarching aim has been to provide women with the tools needed to transition from victims to survivors with full citizenship rights. Breaking this down further, there are two key components to this work. One, to give voice to those who are easily silenced, and two, to ensure that the state protects the most vulnerable amongst us and guarantees citizenship and human rights without violating wider human rights and the rule of law itself. And this last part of the equation is essential to the feminist project, since women's freedoms cannot exist in the absence of a thriving democracy. In the UK, perhaps the urgent and contemporary challenges that we face as feminists are nowhere better encapsulated than in women's engagement with the criminal justice system and other state institutions in a context of rising violence against women and girls and failing state responses. Data from the Office for National Statistics show that in the year ending March 2020, the Crime Survey for England and Wales estimated that 1.6 million women aged 16 to 74 years experienced domestic abuse. That is 7% of the female population. For the same period, just under 3% experienced sexual abuse and 5% experienced stalking. In the same year, police recorded crime data showed that almost half, that is 46%, of adult female homicide victims in England and Wales, that's 81, were killed in a domestic homicide. But these figures don't tell the full story. Statistics around more specific forms of harm and violence against women and girls within minority communities, such as FGM, forced marriage, so-called honor-based violence, are less reliable, since there is huge variation in how they are counted, if at all, in official data on domestic abuse and domestic abuse-related homicides and suicides. Domestic abuse-related suicide rates amongst minority women, for example, can be up to 3 times the national average, but they are not systematically gathered or updated, with the result that in the UK, as in every country, there are enduring silences surrounding the experiences of the most marginalized groups of women who remain excluded from the statistics and consequently from public discourse. Yet we know from anecdotal evidence that Black and minority women face disproportionate rates of all forms of gendered violence, much of which remains hidden. In her 2016 review on opportunity and integration in isolated and deprived communities, Dame Louise Casey, who recently hit the headlines with her review of the Met Police's response to domestic and sexual violence, Dame Louise Casey noted that minority women and girls, especially South Asian women, face multiple challenges in seeking support in the face of domestic and sexual violence. She noted that many of the Asian women that she came across were abused and isolated, and concluded that the advances made by women on equality in the country generally were not reflected in those women's lives. And she says, and I quote, "In many areas of Britain, the drive towards equality and opportunity across gender might never have taken place. Women in some communities are facing a double onslaught of gender inequality, combined with religious, cultural, and social barriers, preventing them from accessing even their basic rights as British citizens. And violence against women remains all too prevalent in domestic abuse, but also in other criminal practices such as female genital mutilation, forced marriage, and so-called honor-based crimes." So although Dame Louise Casey was referring specifically to South Asian women, her findings reflect the circumstances of many minority women who live, especially those who live in conservative and tight-knit communities in which gender-based violence and inequality is pervasive. It is against this reality that Black feminist struggles for state intervention in its protective capacity in respect of crimes of violence against women and girls have taken place. For example, we've seen changes in criminal laws and policies around battered women who kill that led to the abolition of the law of provocation, which was built on male norms of behavior. The high point of this work during my time at Southall Black Sisters was the high-profile case of Kiranjit Ahluwalia, who killed her husband after suffering abuse at his hands for 10 years. I know some of you will know about the case. I'll just give a little bit of background because somebody said, I hope you talk about that case. When we first took up the case of Kiranjit Ahluwalia at the tail end of 1989, she had already been charged with murder and was awaiting trial. The background is that she set fire to her husband following an argument in which he assaulted her and threatened to burn her face with a hot iron. Although she had obtained a court injunction restraining her husband from harassing or assaulting her, she stayed in her marriage due to family and cultural pressures, to live by the patriarchal concepts of honor and shame, and to uphold her duty as a wife. At one point, in order to manage the violence that was escalating over time, she agreed to renounce all her desires and her very identity in an effort to please and keep her husband, who was also having an affair. In a letter to her husband, which amounted to a charter of slavery, she said she would stop eating and drinking things she liked, would stop visiting friends and relatives, and stop laughing. Following the death of her husband, Kiranjit's family instructed lawyers to represent her. So all we could do was attempt to work with the legal team to ensure that her history of abuse was understood by them and by the trial court. However, this itself was an uphill task, as her legal team failed to show an interest in examining the very real practical culture and religious constraints that prevent women like Kiranjit from exiting abuse and instead drives them to commit such crimes. Needless to say, Kiranjit was found guilty and convicted for murder without the court having considered her experiences of abuse within her specific cultural context. By then, some of us had watched a US documentary film entitled I Shot My Husband and No One Asked Why, in which a range of women talked about how the criminal justice system in their cases was preoccupied with only the event itself and not what led up to the event. The issues raised in the film strongly resonated with the experiences of women like Kiranjit in the UK. At the time, I remember I was really struck by the fact that the very term miscarriage of justice was only ever used in respect of men who were wrongfully arrested and imprisoned in politically charged cases, but very rarely applied to women who killed violent men. This itself signified to me the political and legal battles that lay ahead. We knew that it would be difficult to overturn her murder conviction, given the biased nature of homicide laws at the time and the wider lack of understanding of domestic abuse and its impact on women in the public consciousness. Mounting an appeal on behalf of Kiranjit raised a range of questions and issues to do with the unequal treatment of men and women within the criminal justice system, and in particular the gendered nature of homicide laws that failed to recognize women who killed in self-defense or as a result of serious or long-term abuse. Whilst we were comfortable in challenging the inherent discrimination of homicide laws which worked in the interest of men, we were less sure about how to formulate our feminist demands whilst also avoiding stereotyping abused women's behavior or seeking a license to kill. At the same time as developing a legal strategy for her appeal, we also realized that if we were to succeed, we needed to mobilize a major campaign to gain widespread media and public support. This was critical in order to apply pressure on the Court of Appeal to understand the actions of Kiranjit and women like her that are born out of fear, desperation, and the need to survive rather than out of revenge or self-gratification. The campaign to free Kiranjit brought together women, young and old, white and black, activists and professionals, survivors and women's organizations, in a series of noisy and colourful protests outside the Home Office on a weekly basis. Okay, imagine that now. And at the Court of Appeal in 1994, when her appeal against her murder conviction was finally heard. We joined Kiranjit's campaigns with that of others led by the campaigning group Justice for Women, concerning white women like Sarah Thornton and later Emma Humphreys, who had also been jailed for killing their white violent partners. So we joined together in an act of solidarity. And these campaigns captured not only the feminist imagination, but also the public's too. And I promise you, when we started out, we did not expect the kind of attention that we finally got. And we had no idea what we were doing and where it was all heading. But it significantly led to much needed reforms of the homicide law, in particular the law of provocation, which was eventually abolished and replaced by the law of self-control, loss of self-control. Kiranjit's case was also groundbreaking because it exposed the ways in which the voices of those who are the most powerless and marginalized in our society are silenced by the law itself. It helped to unmask the idea that the law is neutral or equal or objective, not only on issues to do with gender, but also race, and to highlight the gap between the law and justice, showing that they are not necessarily the same thing. Since then, feminist campaigns have mobilized, for example, around the 2018 War Boys case at the UK Supreme Court, involving police failure to investigate rape complaints. And this case established the principle that the police have a legal duty to investigate serious crimes of violence under the Human Rights Act 2010. And in 2019, we witnessed the groundbreaking Court of Appeal case of Sally Challen, which has led to a wider understanding of the concept of coercive control as a key driver of violence against women and gender inequality. At the same time, incessant campaigning by Black and minority feminists have enabled us to put to bed the worst aspects of state policies on multiculturalism that failed to recognize forced marriage or FGM and honor-based violence as forms of abuse and violence, rather than as cultural practices that had to be tolerated. Hanana talked about that earlier. In fact, our work around this led to the creation of new laws, such as the Forced Marriage Civil Protection Act, alongside statutory guidance and policies setting out good practice, all of which were unthinkable a few decades ago. There have also been a plethora of other criminal and civil laws, policies, strategies, action plans around violence against women, which recognize that physical, sexual, financial, and psychological abuse form part of a continuum of abuse and patriarchal control to which women are subjected in the private sphere. Even in the sphere of immigration, where positive change is almost impossible to achieve, through campaigns over the last 3 decades, we've managed to soften the edges of the UK's increasingly harsh immigration regime through reforms that allow some migrant women subject to abuse the right to access protection without fearing detention or deportation. And that was, again, discussed earlier today. In 2002, for example, SBS successfully campaigned for the introduction of the domestic violence rule, allowing women on spousal visas a route to apply for indefinite leave to remain if their relationship broke down due to domestic violence. Further campaigning and lobbying, and a decade later, led to the creation of the Destitution and Domestic Violence Concession in 2012. This gives those holding spousal visas access to limited state benefits and emergency housing, pending their applications under the DV rule. What these 2 pieces of legislation have done is provide a really effective model of protection for migrant women with insecure status, because it not only allows them to exit abuse and without fear of deportation, as long as they can show that they're victims of domestic abuse and that they fulfill other immigration criteria, but it also allows them to claim benefits whilst their applications for settlement are pending. And as we all have discussed today, unless material needs of women are met in terms of alternative housing, food, medical support, there is no way that we can, expect them to exit abuse easily. More recently, in 2022, and I'm really quite proud of this, following a successful 7-year campaign and a legal intervention in a High Court case involving a woman who had been brought to the UK following marriage and then abused and eventually abandoned back in Pakistan, we succeeded in having the phenomenon of transnational marriage abandonment recognized in law and policy, both in family and immigration law and policy. That is a really, I'm really proud of that, because that is the beginnings of us trying to look at the issue of migration and marriage in that transnational context and find strategies and ways of resisting, that allows that to happen. The phenomenon of abandonment, known as transnational marriage abandonment or stranded spouses, is a form of violence against women that occurs in these transnational spaces because of the overlapping of marriage and migration. It refers to the plight of married women who deliberately left without resources in their countries of origin by their overseas partners, on whom they're entirely dependent for their social and financial survival. It is a form of domestic abuse in and of itself, since it always occurs in the context of other forms of gender-based harms and is part of the dynamics of coercive control that women suffer at the hands of their husbands and in-laws. Sometimes women are cruelly separated from their children, and others are abandoned with their children. They're left trapped in abusive and limping marriages and in circumstances that involve a deliberate violation of their legal rights to protection, support and rehabilitation in the UK as victims of domestic abuse. So the transnational nature of the problem raises specific challenges for women seeking justice, mainly because it's located across a number of jurisdictions and has until recently given countries like the UK an excuse to avoid responsibility. And actually, a lot of the women actually come from the Indian subcontinent. And what you have is the Indian government saying it's not our responsibility and the British government saying it's not our responsibility. And it gives all these states an excuse. But now, thanks to a landmark High Court judgment given in October 2022, it makes clear that the Home Office failure to make provision for abandoned spouses to re-enter the UK, to assert their settlement rights under the domestic violence rule, amounts to unlawful discrimination within the meaning of Article 14 of the European Convention on Human Rights, and read with Article 8, which is the right to family life, under the Human Rights Act as well. This judgment is all the more remarkable because it is rare for a court to uphold a claim of discrimination under Article 14 against the Home Office. It's very rare to get judgments against the Home Office on the grounds of discrimination. And yet, if you think of the entire immigration infrastructure, it is racist and discriminatory. The fact that it was given against the background of an ultra-hostile environment immigration policy makes it even more significant, because it really helps to counter the despair that often engulfs those of us not used to seeing instantaneous progress in the struggle for migrant rights and justice. Yet, as welcome as all these developments are, they have failed to eliminate or even diminish the central tension that runs through our engagement with the state. On the one hand, we continue to grapple with state overreach or over-policing, which involves the intensification of state powers of coercion and control. And this was highlighted so viscerally in December 2020 in the case of Child Q. I don't know, some of you will remember that case. This was a case of a 15-year-old girl of African Caribbean background who was subjected by the police to a strip search involving exposure of intimate body parts while she was menstruating and at school. No appropriate adult was present during the ordeal, which had taken place without parental consent or knowledge. The police had been called by the teachers at the school, who claimed she strongly smelt of cannabis and suspected that she was carrying drugs, but none were found during the subsequent search. An official investigation in March 2022 found that racism was likely to have been an influencing factor in the actions of the police officers. Arguably, though, nowhere is the tension arising from the state overreach starker than in the growing nexus between the functions of the police and immigration authorities, characterized by surveillance and brutal enforcement. In February 2020, for instance, we witnessed the acquittal of a Nigerian rape survivor of charges of assault. The case concerned events in May 2018, when she was subjected to an unlawful and forcible removal from Yarlswood Detention Centre onto a plane by 11 private security guards hired by the Home Office. Ignoring a court order staying her removal, the guards had placed a blanket over her head, making it difficult for her to breathe so that she feared she would die. The judge said that the amount of force she used in defending herself while she was being restrained was wholly reasonable. In other words, the Home Office tried to sue her for assaulting the private security guards that had assaulted her. On the other hand, we have seen cases where the police continue to under-police domestic and sexual abuse on an almost industrial scale. For example, in August 2018, the jury in an inquest hearing into the homicide honor killings of Raneem Uday and her mother Koala Salim, both of Syrian origin, determined that inaction on the police materially contributed to their deaths. So these women were stabbed to death outside Koala Salim's home in Solihull, Birmingham, by Raneem's possessive Afghan origin husband, who prior to the killings had engaged in a year-long campaign of physical abuse, stalking and harassment towards Raneem. He had made repeated threats to kill her both before, during and after her marriage, when she tried to separate. Much of the harm that he inflicted involved extreme levels of coercive control and physical abuse, which was reported to West Midlands Police, both by Raneem and by third parties such as her neighbour, a housing officer, and paramedics on 8 separate occasions. So unusually in this case, we talk about domestic abuse being a private form of harm. Unusually in this case, there were independent witnesses. Yet each time the police were called, they failed to properly assess the risks to her or to take adequate safeguarding action or arrest her husband for various offences that he had clearly committed in the course of his abusive conduct. Their response betrayed a complete lack of understanding of the dynamics of domestic abuse and coercive control, and how the risk of serious harm intensifies for many women at the point of separation. And our work and the evidence shows that when women say that they're going to divorce or that they're going to separate, the risks just escalates. It's at that point that the risk becomes very great. But the police fail to appreciate this. And it's particularly pertinent in cultures in which the honor code attaches stigma and shame to female separation and divorce, and justifies the use of violence to minimize such shame. Indeed, one of the standout features of the police response in this case was their complete failure to identify the warning signs of honor-based violence. No effort was made by the police to pick up the indicators of honor-based abuse or to understand what Raneem was saying about her fear of violent retribution born out of her husband's strong adherence to the honor code. This attitude also coloured the response of social services to Raneem and her child, who was also at risk of harm. The inquest jury looking at this case identified multiple police failures that contributed to their deaths and concluded that many opportunities to protect her were missed. But sadly, this is not the first time the police response to culturally specific forms of harm, such as honor-based violence, has resulted in fatal consequences. In January 2006, we witnessed the horrific killing of Banaz Mahmood, and Hanana talked about this, an Iraqi Kurdish young woman who was killed by her father and extended male family members. Her body was found in a suitcase buried in a Birmingham garden in 2006. She was a subject of an honor killing by male members of her family who tortured and raped her before strangling her because they disapproved of her relationship with her boyfriend. Prior to her death, she had reported threats and attempts on her own life and that of her boyfriend on 4 separate occasions to the police. She was dismissed by the police for being melodramatic. And on one occasion, they even considered charging her with criminal damage for breaking her neighbor's window in an effort to escape from an attempt by her father to kill her. Her experiences highlight how we continue to experience high levels of under-policing when it comes to domestic and sexual violence, including specific cultural forms of harm that still attract little or no state intervention. This is one reason why the numbers of women killed by their abusive partners has not changed for decades. Some would say they have increased, and why rape convictions are dismally low and diminishing. In some minority communities, such under-policing often goes hand in hand with the adoption of a culturally relativist approach to rights and justice, one based on the misguided view that religious and cultural practices, irrespective of the harms they may cause to women and children, must be tolerated and or addressed through community and religious gatekeepers. In the process, the state ends up helping those gatekeepers achieve their key goal, which is to maintain the patriarchal status quo and to retain their monopoly over power and resources at the expense of the human rights and freedoms of women and children. The continuing nature and scale of police failure in such cases point to a deeper, ingrained institutional culture of misogyny, which views all forms of gender-related abuse not as criminal matters or not as a criminal matter of public interest, but as a private matter for which the victim needs to take responsibility. It is a culture that is predicated on prejudicial notions of women as inherently inferior, which then serves to maintain the patriarchal status quo. This raises questions about what is to be done when an effective police response is consistently undermined by poor or flawed implementation of law, policies, and guidance on gender-based violence or culturally specific forms of violence. No one living or working in the UK these last few weeks could have failed to note that last month the Casey report into the policing of gendered violence was published. It made for grim reading. It was scathing in its criticism of the Metropolitan Police response to domestic and sexual violence, which was found to be institutionally racist, misogynist, and homophobic. The report highlighted how the institution, the biggest police force in the country, is shrouded in a culture of bullying, harassment, and corruption, contributing to a crisis of confidence and rapidly diminishing public trust. For many of us, as has been pointed out, the findings were neither shocking nor new, since many previous investigations and inspectorate reviews into police responses have found similarly persistent failings that make a point, that all point to a police force that is unfit for purpose. What the Casey report says of the Met Police is just as true of police forces elsewhere in the UK, and I talked a bit about the failings of the West Midlands Police Force earlier. And it raises wider questions of what it will take to effect change. Throughout my time at SBS, We routinely filed complaints where the police provided an inadequate response to women who reported abuse. In the majority of the cases, the complaints were dismissed, and occasionally, in the more extreme cases, partially upheld, but this did not lead to disciplinary action against the officers concerned. At most, we were told that the police officer would be given words of advice. And I should stress that at no point did we have any illusion when making the complaints that they would amount to anything. But that wasn't the point. Our aim in making such complaints was to document the systemic failures within the police force and to ensure that at some point in the future, if and when there is a political will to do something, valuable lessons will be learned. Our concern about the policing of violence against women is not so much about the lack of effective laws and policies. There are many. There are too many. In fact, every time you raise an issue, the government's willing to throw a criminal law at it. But it's about the implementation of the laws and policies that exist. Consistently effective and sensitive implementation of criminal law and policies on domestic violence remains an elusive goal. There are still unacceptably wide variations in police responses across the UK, ranging from the ignorant to the negligent and oppressive, as I have shown. In some cases, we have often assisted families of deceased women or seriously injured women to file legal actions against the police in contexts where the harm and death has resulted from police failure to protect women. What most of the cases highlight is a failure of the state to exercise due diligence in either preventing and protecting women in circumstances where the risks to their lives are known or ought to be known. Assisting families to seek accountability from the police inevitably involves invoking international human rights laws and standards, such as those contained in the European Convention on Human Rights, CEDAW, and the Convention on Preventing and Combating Violence Against Women, the Istanbul Convention, all of which place an obligation on contracting states to prevent, investigate, punish, and provide reparation for acts of violence. The need to simultaneously resist racism and state oppression whilst also struggling for women's rights in the family and community have involved adopting what is now widely recognized as an intersectional lens. Unfortunately, much of the debate and practice around intersectionality has reduced the concept to a simple matter of recognizing multiple identities of individuals rather than understanding it as a framework for deconstructing women's social positioning that captures both the structural and dynamic consequences of the interface between two or more systems of institutional discrimination and power. The intersection of patriarchal control and immigration policies is a case in point. It is often said that the vast majority of immigration laws and policies create exclusionary and discriminatory racial processes that deny access to the welfare state and citizenship rights to the majority of migrant women who do not have spousal visas and are facing abuse. But that's not all. The same laws also reproduce and reinforce gender inequality and patriarchal power. By forcing most migrant women into economic dependency on their spouses for their survival, immigration policies create conditions that generate heightened forms of coercive control. Perpetrators routinely subject such women to domestic abuse, imprisonment in the home, domestic servitude, cruelty, neglect, and in some cases abandonment in the countries of origin. They confiscate essential documents and keep women deliberately uninformed about their status. Laws that therefore deny women access to key welfare services that key welfare services and benefits that form a crucial safety net for other abused women allows perpetrator to weaponize immigration laws to keep women in a permanent state of vulnerability and subjugation. The intersection of immigration controls and domestic abuse, in effect, gives rise to new techniques of patriarchal surveillance and control. The result for migrant women who face violence in the home is a continuum of private and state violence. Most migrant women are too afraid to report their experiences of domestic abuse to the police for fear of retribution from perpetrators and from the state. When they do summon up the courage to report, they find that their accounts are dismissed, trivialized, and discredited by the police. In some cases, far from being assisted and protected as victims of abuse, they are subject to investigations and even arrested, cautioned, detained, and charged with immigration offences, and we heard about that this morning. This state of affairs seriously undermines the protection principle that ought to drive the work of statutory bodies charged with an overriding duty to safeguard vulnerable adults and children. The problematic practice of data sharing between the police and immigration authorities for state surveillance purposes was the subject of considerable campaigning by Black and minority feminists during the passage of the Domestic Abuse Act 2021. However, in the face of findings by various police inspectorates and regulatory bodies that such data sharing causes significant public harm, the government has pressed ahead with the practice. In doing so, the government has chosen to prioritize the so-called integrity of the immigration system over the protection of migrant women. We consider that the continuing exclusion of most migrant women from protection amounts to the breach of the UK's obligation under domestic and international human rights law, and in particular the European Convention of Human Rights, Article 2, which is the right to life, Article 3, the right to be free from inhuman and degrading treatment, and Article 8, the right to private and family life, including physical and moral personal integrity, especially when taken together with Article 14, which is a non-discriminatory clause in the enjoyment of substantive rights. It is also in breach of the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, and in breach of the Istanbul Convention. So, what do we do in the face of unchecked institutionalized police racism, misogyny, and brutality, and against the backdrop of the Black Lives Matter protests that we have witnessed? What we've seen is a growing momentum of the anti-carceral movement, which questions whether feminism has reached the limits of its engagement with the criminal justice system. These questions are based on the view that the feminist use of the criminal justice system serves not to empower or liberate, but to further marginalize and criminalize women, especially those from racial minorities who are disproportionately at risk of state-inflicted harm. Whilst I agree with the urgent need to look beyond the criminal justice system towards a more holistic approach to justice that also addresses the economic and social conditions that shape gendered violence, I consider that anti-carceral politics also raise a series of other dilemmas and concerns that have yet to be properly addressed. In particular, who or what fills the space vacated by the police and the criminal justice system, given that non-state actors can also wield systemic carceral power through the patriarchal institutions of religion, family, and community, a power that manifests predominantly in intensified moral policing and coercive control, generating the very forms of gendered violence and harm from which women need protection. In the last 3 decades, the rise of neoliberalism, combined with the growth of religious fundamentalism and conservatism in minority communities, has led to the creation of a social contract based on a hyper-masculinized and patriarchal sexual order, especially in South Asian communities, and it has brought with it increasingly violent mechanisms of female subjugation and the suppression of feminist dissent. It is well documented that all women share similar experiences of domestic and sexual violence, but many minority women can face additional and specific forms of harm arising from culture and religious dynamics and values that reproduce highly gendered norms and sex inequality. Indeed, as the report from Dame Louise Casey report on integration shows, and I quoted earlier, most Black and minority women's experiences show that there is a direct link between regressive gender norms that subscribe their participation in public life and the incidence of violence against women and restrictions on their freedom in the private life. As a consequence, my work on violence against women has also been directed at wresting control and power away from religious leaderships and family and community elders that deny women and children the right to access the formal legal system or other institutions of the state in order to assert their rights to protection, choice, and autonomy. I've seen how, in the face of a shrinking welfare state and cuts to services, including draconian cuts to legal aid, women are being forced by religious fundamentalists and ultra-conservative forces to turn to religious laws and community-based forms of arbitration and dispute resolution, especially in relation to matters to do with marriage and the family. And here, a lot of what I'm saying resonates with the earlier paper about Muslim personal laws in Sri Lanka. Those who refuse to go to religious arbitration risk becoming social outcasts and worse. Clearly, these are dangerous patriarchal processes that serve only to enhance religious and social control of women and other minorities deemed to be deviant, and are ultimately, and this is my real point about these alternative forms of justice, they're ultimately even less amenable to demands for accountability and gender justice. What is clear is that all these developments have left us reeling on many fronts and scrambling for appropriate strategies by which to fight back. Some of the contributions today have highlighted specific strategies for survival and resistance adopted by women in places like Nepal and India. For example, using the medium of street art, theatre in the UK, and photography in India and Nepal and places. These protest strategies aimed at subverting cultural norms were not only an important means by which to raise consciousness about gendered violence, but also a means by which to make women visible and to mobilize change in pursuit of the feminist goal of empowerment. In my view, if we are to lay down the conditions that give women the best chance of survival, then these strategies are as vital as the legal and political strategies that I and others have invoked in our work in the UK to make the state and its institutions more accountable to women's needs. Those who work on the front line know only too well that daily engagement with the formal justice system and other state institutions is a necessity if women and children are to be protected from abuse and violence and obtain a semblance of justice. At the same time, we are confronted with an increasingly controlling state that makes progress difficult, threatening not only to wipe out the feminist gains that have been made, but to take away the very tools that we need to hold state and non-state actors to account where they abuse power. Despite the authoritarian and austerity-driven undercurrents of much of state action and social policy, we have no choice but to conceptualize and challenge the state to ensure that it serves as the ultimate guarantor of women's human rights. This is why, in my view, feminism cannot afford to vacate the justice system or state institutions as key sites of feminist resistance, even as we recognize and challenge the state's increasingly coercive and punitive interventions that deny women and others access to rights and justice. I think the real challenge lies in working out how we strengthen mechanisms for accountability for the abuses of power that are routinely committed against women and girls in the public and private spheres, and in how we continue with our political demands to that end. If the feminist project is to be viable, we need to use all the legal, political, and cultural strategies available to us to mount a multi-directional challenge against the oppressive hierarchies and systems that stand in the way of survival, resilience, and progress. Thank you. Have I gone well over time?